I'm Charlene Chamberlain, and you're watching and listening Morning Coffee. And I'm here with my lovely guest host, Barbara Friere. It's so nice to have her with us today.
Thank you.
She's usually on the other side of the camera, and it's a treat for her to be here with me today.
Thank you. Thanks, Charlene.
Good to see you again. And we had a really great segment with Dr. Cohen this morning. We learned a lot about bullying and losing weight and self-sabotage and all that stuff. So we're on to our next guest now, and I will let Barb introduce her.
Yes, this is Betsy Ramos, and Betsy is an executive committee member and co-chair at Capehart Scatchard firm in the litigation department, and their main office is in Mount Laurel, New Jersey. And Ms. Ramos litigated over 25 years, including tort, defense, estate, insurance, coverage, business, employment, construction, litigation, civil rights defense. Lots of things.
Yes.
Ms. Ramos is certified by the Supreme Court of New Jersey as a civil trial attorney and AV rated by Martindale-Hubbell, the nation's oldest and most prestigious law rating service. Betsy always receives the highest rating in both of these. She received her law degree from Vanderbilt University School of Law and her BS in economics from the Wharton School of Business, University of Pennsylvania. She's licensed to practice in New Jersey and Pennsylvania. That's a lot. Very impressive background, Betsy.
I think even I'm impressed now.
Oh my God, did you remember all of those things?
You know, that happens sometimes. You forget.
There won't be a quiz later.
Oh, no quiz.
As I was writing, I was like, oh my God, this is a novel. You've done a lot.
Well, I've been practicing, as you can see, for many years.
Right.
And one of the areas I do practice in, which is what I want to talk about today, is estate litigation.
Right.
I hope that people will benefit from some of the experience that I've had so they can learn by the mistakes of others.
Right. And you know, Betsy, that's a topic that addresses everyone. Everyone needs to deal with an estate or should be dealing with the estate issues. So,
and especially we have so many baby boomers now that are dealing with their parents' estate issues as well. So I think that is really a hot topic.
Some people just don't plan, or they just can't face it. And
they're in denial.
Yeah, they don't want to face
it.
it.
They're in denial, or they haven't updated their plans. We have people that come in and that have elderly parents, and unfortunately at that point, if they don't have an estate plan and they have dementia, then they can't do it.
Right.
So people should be more proactive and they'll have to face their mortality, and they should know that they can always change it.
Right.
As long as you're competent, you can always change it.
Now, Betsy, when is a good time for someone to do a will or do estate planning?
Well,
at what time in your life?
Sure. What I tell people is, if you have real property, if you own a home, or if you have young children, that's when you should be looking at doing your first will.
Okay.
Right? And it's usually at that point probably a simple will. As you gather more assets and more wealth, then it might become more complex. You may need a trust. But at least at that point in your life, that's when you should first be looking at a will. And one of the reasons for it, particularly for if you have a child, in your will you can designate if you and your spouse both perish in a common accident, you get to designate who will be the guardian of your child.
Right. Very important issue, obviously.
I have a question though. What happens if you do pass away and you don't have a will?
Well,
I'm sure there are many variables that would play into that, but the main problem would be...
Well, the main problem at that point is if you don't have a will, all of your estate passes by the laws of intestacy. And the laws will vary by state. But in New Jersey, if you don't make a will, then the government decides who gets your assets.
And it also ties it up a while too. It's not that instant process.
Probate, right?
Well, it can tie it up because there might be a fight over who will be an executor, over who will be governing administering your estate.
So the state of New Jersey or whatever state you're in would appoint an executor?
Well, someone does have to apply for it,
okay.
But the problem is if you have money, and I'll be cynical, if you have money, more than one person might want that job.
Because there is a payment to become an executor, right?
Well, you do earn a commission.
Okay.
And there's a flip side of it. If you don't have a lot of money, maybe no one wants the job.
Right.
But if you don't do the planning, then you lose the opportunity to be able to make sure whoever your heirs are or actually get the property that you want them to have.
Right.
You lose the opportunity of choosing the person who will administer your estate. That's called the executor. You lose the opportunity to perhaps set up a trust that might be beneficial to one of your beneficiaries. You lose the opportunity to do any kind of tax planning. And as I mentioned, if you have young children, you lose the opportunity, if both you and your spouse both die, to be able to choose who will be their guardian.
Which is tremendous. That's a tremendous thing.
Right.
I mean, everybody really should be doing a will at the stages that you're mentioning. And then the other thing is, it gives the person who, like the elder person, peace of mind that they know this will be taken care of according to their wishes.
Right.
Because so many people, I have people, my financial advisor said to me that people come and say, I'm here about my inheritance. He goes, wait a minute. This is not your inheritance until they pass. It's really their wishes of what has to happen with their money and their belongings in their estate. So it really is to carry out what that person's wishes are, not the person that inherits what they're going to get.
That's very true, and you can be as detailed as you would like. You can put in your will, you want your son or daughter to get a certain painting or your jewelry or your glass collection, and you lose that whole opportunity if you don't have a will.
Right. And then I would imagine there would be a lot of infighting between siblings for tiny little things that probably don't mean much.
There is. Unfortunately, when there's money or there's assets involved, it often brings out the worst in people. And I get involved when there are those type of disputes and there's litigation over a will that wasn't properly drawn up, and now there's a will contest, or if there's no planning, and the person thinks, well, everything will just pass by a joint bank account or it's a joint asset.
No.
It's actually not that simple.
Right. I have to say, unfortunately, I lost my father and my stepmother, and I handled their estates, but it was seamless, even down to the services were already prepaid. You're going through a hard enough process in itself at that time. It makes it just so much easier. I made one phone call to the lawyer. I had the will. I had the healthcare surrogate along the way, which maybe you want to mention. And it just made the process, a hard process, easier. And according to his wishes. So it made
it's such an emotional time, and it's hard maybe to make an educated decision too, because
you're not even
thinking
straight. You're not even thinking straight, and then it just makes it so much easier that was all planned thanks to going to an attorney like yourself.
Well, if you do it right and you have a will, then whoever is the executor just has to walk down to the surrogate's office, sign some documentation, and they get a short certificate, and they're on their way. If you don't do it right,
I was just going to say, you said if you do it right. So what
if you
makes it do right?
Well, there are some, especially in New Jersey, you can have what's called a self-proving will. If you have certain magic language at the end of it, and you have 2 witnesses, and it's notarized.
So that would be something a document or something you would write up yourself?
Well,
I mean, you could, and then the internet, they can print out a form, I guess.
Well, I'm glad you mentioned that, because with the internet, people think, oh, I don't need to pay money. I can just do this myself. Well, and they go to the internet, they find a form. I mean, there's almost anything you can find in the internet. Well, that's under the rubric of you get what you pay for. And if you do just download a form, it may or may not fit your needs. It may not address all of your concerns. It won't ask you any questions. And if it does, if it is interactive, it may not ask you all the right questions. It may not, for instance, you may decide, gee, I want both my kids to be executor. That may not be such a good idea. It's good now they get along, but in 20 years when they're not speaking to each other, what happens then? I usually recommend just one person as an example. So while you can do it, just think about it. You've spent all these years accumulating wealth, accumulating assets. You have loved ones. You want to make sure that it's seamless, like you said. Invest a little bit more money and go to a lawyer and have it done right. So you won't need to hire me.
Or they'll hire you the first time. I mean, because if there's an issue, they come to you.
That's true.
They don't come to you just to do the will.
We have.
But you have a division.
I handle the litigation, meaning that there is some dispute. We have a department that actually
handles
does the
wills.
planning. And I work hand in hand with them as well. I work with them if there is a dispute. But better to plan first. Better to be proactive.
Right. So let's talk a little bit about if you have a business and you're married, and do you include that in your wishes, in your will, or like a succession plan or something like that? How do you handle that?
I'm glad you raised that because, I was just talking about perhaps a simple will. If you have a business, that does involve a little more complex planning because because there are a lot of decisions that need to be made. You have people that have had a business, they've started the business, or maybe it was their family business.
It's handed down.
It's been handed down, and you want to make sure that business will continue on after you die. So
hopefully, right.
So there are decisions that have to be made, and it does go hand in hand with your estate planning, because one of your major assets of your estate could be your ownership in that business. So your goal would be that you want to make sure, will this business continue? You have to look at, well, who do I want to run the business after I die? Who is best suited?
Right. Who would want to run it?
And
maybe they don't want someone, maybe there isn't someone that wants to step up and take that responsibility.
And it may not be a relative.
Right.
Maybe that there's been no relative.
Partner or something.
Or a board member or something,
It may not be a relative. It may be that you'll sell it upon your death. And just your heirs will get the money from it. But more often than not, if people have invested all that time and energy, especially if it's a family business, they want to know who will be running it after they die. So that's one of the first considerations. The second consideration is, how do you achieve that and have to pay the taxes on it?
Oh, I forgot about that.
So it's very tax driven, and with proper planning, you might be able to gradually give some of the stock, as an example, or have them buy some of the stock. You might have, if it's a partner, maybe you want to have a buy-sell agreement, but then you have to worry about funding. You might need life insurance to pay for it. And if you're 65 with a heart condition, you won't be getting life insurance at that point.
Right.
So you want to think about it when you're a little younger and good health. If you do need life insurance, or you might get it, it'll be very expensive. If you do have, say you have 3 children, only one of them is in the business. And so that's the natural who would take over. But then you'll want to think about, well, I do want to provide for my other 2 children.
Sure, out of the business.
So how do I do that?
And so you think of some way to either provide for them out of the income of the business, or to provide for them otherwise. Maybe they get some bank accounts, or maybe they get some other assets that you own, and so that they're provided as well.
Right.
So there are a lot of considerations. If you do nothing, again, this is under the do nothing.
Right.
If you do nothing, what could happen is that business, that stock ownership you have in that business, that's one of your assets.
Right.
It gets valued when you die, and then there are taxes that are due. And if you haven't planned, you could end up with a very unfortunate event of having to sell the business just to pay the taxes.
Oh, sure. Oh, my heavens. Yes. These are things that you know, Betsy, that we don't,
we
the
don't
audience
even
and not
think about.
necessarily think of.
Right.
And I hate to interrupt, but we have to take a short commercial break. We'll be back with Betsy Ramos from Capehart Scatchard.
Kick off your new year at the Croc Center, helping families achieve their full potential with fitness facilities, indoor competition and play pools, performing arts theater, educational programs, and fun for all ages, including seniors and teens, on our 24-acre campus in the Kramer Hill section of Camden. Book now for birthday parties and corporate events. Monthly memberships start at $25 for a household of 4. The Ray and Joan Kroc Core Community Center in Camden, where potential meets opportunity.
For independent living for seniors age 62 and over, People Inc. offers safe, maintenance-free apartments across Western New York. The affordable rent is income-based. For more information, call People Inc. Senior Living at 817-9090.
Looking for a cooking oil with a light flavor and reduced absorption so food preserves its natural flavor? One with a high smoke point for stir-frying, sautéing, grilling, and baking? Then choose all-natural Pompeian 100% grapeseed oil, imported from France. Grapes have been a key ingredient of the healthy Mediterranean diet for years. Pompeian 100% grapeseed oil is the chef's choice for high-heat cooking, grilling, stir-frying, sautéing, or even deep frying. And Pompeian 100% grapeseed oil is great for baking too, because its delicate taste does not overwhelm the flavor of cakes, cookies, and other favorite recipes. A key traditional ingredient of the Mediterranean, grapeseed oil is a rich source of vitamin E antioxidant and naturally gluten-free. Buy imported Pompeian 100% grapeseed oil today and find great recipes at Pompeian.com.
Wait, don't let this happen to you. At Jan Fence, we're family owned and operated for over 50 years, providing a wide choice of fencing. Why wait online at the big box store? Just call Jan Fence. Ask about our Easy Fence to Go products by Active Yards, the first truly do-it-yourself fence product.
At Jan Fence, we always do what we say. Come see us today.
Step into an extraordinary world that will excite your senses. Experience our delectable Mughlai cuisine and the magic of tandoori savoir-faire. Let our international award-winning team delight you with a taste of heaven. Enjoy our mouth-watering flavors and our unique flair for excellence. Savor the elegance of fine dining and catering. Shazam Restaurant.
And Betsy Ramos, an attorney who has been filling us in on estate planning, executorship, and POA, and we're going to talk right now about what documents are really needed when you're at that point in your life and you don't have any of these documents, especially POA.
Well, we've talked a lot about a will, but I tell people there's actually, at the minimum, 3 documents everyone should have. Now, you might, and I mentioned this before, you might need some more complex planning in addition to a will. You might need a trust, but everyone should at least have a will. But there's 2 other documents that actually are very important. Everyone should have a power of attorney.
Yes.
So this way, if you become disabled, there's someone you have designated who can handle your financial transactions, who can help you,
medical,
who can help you. Well, I'll get
That's
to that in a
another one.
second.
Yeah.
That's the other. You should have a healthcare POA
Sorry,
as well, but they can handle all of your financial transactions. They can do your banking. They can pay your bills. If you need admission to, say, an assisted living facility, they can sign your contracts.
Right.
And if you don't have that, the problem is then if you become incapacitated and you're no longer competent to sign that kind of document, then someone has to apply for guardianship for you. And I'll be cynical again, if there's money, everyone wants to take care of mom and dad.
Right.
The other thing that you should have is you should have a healthcare power of attorney, or it's also sometimes called a healthcare proxy.
Right.
And this way, if you become disabled and you can't make your own medical decisions, you can put in that document. It's often called a living will. A lot of people have heard of that.
Right.
And you can put in there what kind of measures you would like to keep you alive. And it could be that you want heroic measures to be taken. It could be you don't.
Right. Depending on the health situation at the time also.
And you can make that choice ahead of time so your loved one knows what to do. But also then, again, it sets up someone who can make the decisions.
Right.
Think about it carefully.
Who you want in charge of your end-of-life care.
Right. Well, it's true.
That's the person who will make the decision whether to pull the plug. And there are some, as you've probably heard, some famous court cases where people were fighting over whether they should pull the plug or not.
Yes.
Oh, sure.
That's an extreme, but this would avoid that if you have those documents. So those are the 3 documents you should have: a will, a power of attorney, and a healthcare power of attorney.
And you know, Betsy, I just thought it when you're saying power of attorney, explain what a power of attorney is. There's a lot of misnomers out there. People think the power of attorney happens with, well, explain what it is, because I get questions on that all the time.
Sure. A power of attorney can be as broad or as limited as you would like, but usually we do it in a broad sense to give them as much powers as possible. But it gives someone else authority to act on your behalf in all of your financial concerns.
Right.
Now, you can always revoke it.
Right.
It can be what's called the springing power of attorney, which, by the way, I don't recommend, which would only go into effect if you are disabled.
Oh.
But
what's it called again?
It's called a springing power of attorney.
Springing. I never heard that term. I never heard that term.
Well, the problem with that is then you have to prove that the person is
in
disabled.
that position.
And I've had 2 situations where that's become difficult. So we don't recommend them in New Jersey.
Okay.
But the power of attorney gives essentially someone the legal ability to act on your behalf in all of your financial affairs.
But while you're alive.
While you're alive. That's correct. The power of attorney ends upon the person's death. And then, assuming you have a will, then your executor would be the person who would be controlling the affairs at that point.
Right. Now, speaking of controlling the affairs, and this is something that a lot of people, another issue too, what happens, can you cut spouses out? I'm seeing a smirk. I see that all the time. I know New Jersey is a spousal state. Certain states have certain rules. It depends on where you are.
Right.
What happens if you're in the will and you're disgruntled or something's going
on?
on?
What if you're still married but you're separated? I mean, legally you're married but not together.
Well,
what happens?
while children, you can cut them out of your will. They don't No, they don't. You
Really?
don't owe them a cent.
So children, you can
Children,
disinherit.
Children, you can disinherit.
Okay.
Not
Children
saying,
got to think of that.
Not,
Be nice to your parents.
Right.
not saying there won't be a legal battle, but
Right.
you can do
Yeah.
it. You cannot cut a spouse out of a will.
Anytime,
not,
any state.
Not entirely. Well,
Okay.
state law might vary.
Okay.
Now, there are exceptions. For instance, if you have a prenup in New Jersey
Mm-hmm.
and that's valid, you can disinherit your spouse.
Okay.
But in New Jersey, and again, states may vary on this, if you don't leave your spouse, if you totally disinherit your spouse, they're entitled to take a third of your estate,
Regardless.
Okay.
regardless. So it's
Oh.
called, they can elect against the will.
Wow.
Now, there are, you take off expenses and you
Right.
add back other bequests you may have made to them during their lifetime, but they end up with essentially a third. So you might be mad at your spouse, but
Right.
unfortunately, you will have to leave them at least a third, or the courts will give it to them anyway. If you're married 6 months or 60 years, unless you've provided elsewhere, you have an agreement with them. In New Jersey, they're entitled to elect against the will. They still get a third.
How about that? So people have to really think about that when they're getting into a marriage, because if they have a sizable estate,
Right.
just in a short-term marriage, they can be giving away a third of it to someone that isn't really necessarily in there for the
Deserving
right
of,
reason.
Or deserving of.
Right,
that-
and then you have families that would say, well, wait a minute, they've been together 5 months and I've been in their life 50 years.
Right, I'm their child.
I'm getting, exactly,
Yeah.
so.
And that is why prenups are so common with second marriages.
Right.
Oh, second marriages,
so
not really
that-
first as
so-
much?
Some do it, but usually you're young and you're in love,
Right.
and you don't
And
think
you
of
don't
those
have
things.
any money, or you don't think about
That's
it.
true, you don't have money, it's not a
Yeah.
Russian issue.
It's
Right.
again, it usually revolves around money.
Right.
And especially when there's a second marriage or there's children, then you have to start thinking about how you want to plan for your children and your spouse to be taken care of when you die.
Okay, all
There's
right.
one more topic I'd like to hit on just quickly, if you can enlighten us a little bit. What happens to your digital content when you pass away? Who has the rights to that?
Especially with this, right now in this internet society, very digital society.
Right.
That is actually a very complex issue. And again, one of the other reasons why we recommend that you do have a will, so you have an executor who will have rights to say shut down a Facebook page
Oh.
Or your website.
or your website. We recommend everyone has passwords.
Right.
And you might have a different password for every account.
Yeah, you have.
That's actually one of the things that we recommend to clients, that if they do use social media, that they give their username and password so that the executor can shut down the site or
Right.
can access the information.
Right, like you said, if the business is going to continue, someone would need to keep up the website, so someone
Right.
has to know how to get into that.
But even your Facebook page.
Right.
And whatever else you're on, Instagram and Pinterest and all those other things.
Yeah, there are some situations where, say, a child has died and their Facebook page stays up forever.
I've had that, I've seen
And
that.
Yeah,
it's
me
it's
too.
unfortunate. The parents want to get it shut down. It's not so easy.
Really?
Because there are agreements with that provider, and it's not so easy to do. But it is something. It is a consideration that people should plan for, just along with their other tangible assets.
So someone
about that?
close to you should have your passwords.
Right. Like we said, it's another thing to think about with the will and estate planning and the healthcare surrogate, the power of attorney, all those
Right.
things. We're here with Betsy Ramos, and she's with Capehart Scatchard. If you want to tell the audience your information.
Yes. If you would like to contact me, again, it's Betsy Ramos, Capehart Scatchard. Our main office is in Mount Laurel. We have a website. As a matter of fact, if you just Google Capehart Scatchard, it'll come up. Feel free to also email me at bramos@capehart.com or telephone at 856-234-6800.
Well, it's been some wonderful information, Betsy.
It
Thank you
has.
so much for coming on Morning Coffee. It was great to have you here.
Okay, well,
We hope to see you again.
thank you for having me.
This is Charlene Chamberlain for Morning Coffee with my guest host Barbara Freer and Betsy Ramos. Thanks for watching.